On this morning's Ag Issues program, it's a pleasure, as always, to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, how are you this morning?
I'm good, Greg, and if you could interpret dreams, it'd be even better, because I had a massive nightmare this morning.
Oh, no.
Bizarre.
That would probably be a whole different program we'd have to do.
Okay.
Boy, weather-wise, mid-60s in the middle of July.
Yeah, I'll take it.
For low temperatures.
Yep.
Let's take it every day of the week. Mm-hmm. So, all right, let's get right into it. And one of the things, or occasionally we've talked about, is the CARES Act that was signed into law back in early 2020. Mm-hmm. Now, one of the things that we haven't had a chance to talk about was a portion of the CARES Act, or an aspect of the CARES Act, is an expansion of the economic injury disaster loans of the Small Business Administration. Mm-hmm. But this is specifically looking at it if you're a farmer, or a farm borrowers, I guess, in this case.
Yeah. This is an expansion of the existing EIDL program that SBA has had. And, of course, SBA was not ever used to working with farmers until the CARES Act came along. And actually, there had to be a lot of arm twisting and bashing them on the head, so to speak, of making them understand that Congress intended agriculture to be eligible for these programs, and EIDL being one of them. Well, once they saw the light with respect to that, Congress then expanded the EIDL program so more farmers and ranchers could take advantage of it, and they expanded the scope of the loans or grants, and really changing the initial grant program, which the funding is largely run out on, to loans. And these can be pretty significant, and you can be a qualified ag business if you have 500 or fewer employees, and that's going to pick up just about everybody in Kansas. If you're engaged in the production of food and fiber, ranching, raising of livestock, aquaculture, they threw that in there, and all other farming and ag-related industries. So it is very broad in its application, and you had to have sustained substantial economic injury from the fallout from the virus, and that's defined as not being able to satisfy your obligations and pay ordinary and necessary operating expenses. Your maximum loan amount is $500,000. So this sounds pretty enticing for a lot of farming operations. Now, fortunately, in agriculture doesn't shut down. It is, as the politicians defined it, it's a necessary business, and so it doesn't shut down at all. But there are some farming operations and ranching operations that, while they didn't shut down, there were supply chain problems, and so they had problems getting product to market. We saw that in the hog industry, some with respect to cattle. If you had a plant that went down because of the virus, you saw it a little bit in the dairy industry also, where you had to dump milk. So there were operations out there that had problems, and so some made application for these loans. Well, when you get a loan, you need to be aware of the documents that you have to sign to get the loan. And that's I wrote a piece on this last week, going through the security agreement language that's associated with an EIDL loan. And Greg, there are some real problems with respect to that.
Yeah, you call it, and it sounds like, succinctly put, you call it the EIDL Trap.
Yeah, I think that's exactly what it is, because farm borrowers may not be aware of the language that's in that SBA security agreement. And I'm not going to go through and detail everything. We don't have time. People can read the article. But basically, that loan is a 30-year loan, and you're going to have to get permission to sell. And it's a blanket security agreement, by the way. They're taking a security interest in all of your farm property, your machinery, your equipment, your livestock, everything. And it's a 30-year deal, the loan is, and you have to go through the SBA to get permission to sell any of that collateral. Now, how many farmers and ranchers keep their farm machinery and equipment for 30 years? Well, there are some. I've got a 52 Ford 8N. So.
Exactly.
Yeah. But, farmers trade equipment, and trades are now we can't really trade equipment from a tax code standpoint. Those are sales, and we route them through the 4797. You have to go through the SBA to get approval to do that. You have to get consents. If somebody doesn't do that and a dealer ends up with a piece of equipment that's been collateralized by SBA, now the dealer's got a problem, the lender's got a problem, the farmer's got a problem. So that's one of the points that I make with respect to that. These consents that are required. And that could be difficult and time-consuming because the SBA has not really been that swift at working with farmers in the past and that fast and up to speed on these types of things. And I would say that is the big one. There's another one in there that deals with an exception we have in Kansas as well as in other states for a buyer in the ordinary course of business. And as I go through in the article, there are a number of gaps in that coverage for a buyer in the ordinary course. And what I mean by that, Greg, is if I buy something in the ordinary course of my business, I'm going to take free and clear of somebody else's security agreement that they've created in that. But there are gaps in that. And you can really fall in some of those gaps and not have the protection of the BIOC statute that we have in Kansas. So I would encourage farmers that if they're thinking about, or lenders, as well as implement dealers that deal in farm equipment, if you have concerns about this, to look to my blog article of July 7.
All right. This next one is interesting because of the fact that this really was generated off of your program, which you can hear here on 580 WIBW, the Agricultural Law and Tax Report, at about 5:35 here on 580 WIBW. And, well, it has something to do with what many farmers and ranchers have, and that's a mailbox. But specifically, let's tie mailboxes and farm equipment together.
Yeah, mailboxes along rural roads that might be narrow. And this is, even though the question came out of Colorado, as a farm broadcaster that runs a station that runs the program in eastern slope of Colorado, even though it came from there, this is a bigger issue in other areas too, although it can come up anywhere. And particularly in the east, where you have really narrow rural roads, and you might have a lot of trees, and there's no shoulder. You know, for example, on the road that goes past our farm in Indiana, where I grew up at, there's absolutely no shoulder. They're not graded; they just kind of go up and down, and they're not really repaired well, and they're always in bad shape. But that's just the way it is. But you've got mailboxes occasionally along those roads, and you're going to take up with all your equipment. We've got a neighbor down the road about a mile from us. Their farm equipment, even though it's folded up, it's such a big operation and their equipment is big, it takes up the entire road and overhangs both sides of the road, even though the wings are up on the equipment that's being pulled behind the implements. So, yeah, it's a big problem. The question I got was specifically, what if I smash a mailbox? Do you just hit and run?
Yeah, exactly.
Well, that's not a good idea. Let's put it that way. And the way I break this down, this was an article that I just posted yesterday on the website. And the U.S. Postal Service has specific rules for placement of mailboxes. So that's the first place you would want to check. It has to be a certain distance back from an intersection. Depends on how much the traffic on the road is, what the distance is. The height of the box has to be a certain place, and the distance from the shoulder or edge of the road. There are specific distance requirements for that. So that's the first thing you would want to check. Plus, U.S. Postal Service rules say that it has to be, the posts have to be within certain specifications, and you can't create something, you can't mount the box on a structure that will not break away if it's hit. Now, that's an interesting one.
Yeah, that one I found.
I am aware. I'm not going to say where it's at. I am aware, and this goes back to my high school days. I was not involved in this, although I have compatriots on the basketball team that happen to be involved with this. Would have fun standing in the bed of a pickup truck with a baseball bat and going down the road and smashing mailboxes. Well, one individual got wise to that and encased the mailbox in bricks. And my colleagues were doing the same stunt and ended up getting flipped out of the bed of the pickup truck. Well, U.S. Postal Service regs say that it has to be a breakaway. You can't really do that. But we know in rural areas that if your postmaster is a good friend, you can kind of do whatever you want to do. So to do something like that, you have to have specific permission of the local postmaster. But that's one thing to check. If you hit a mailbox, make sure it was actually in the right place. Maybe it wasn't in the right place. And then also check yourself, because there are rules that govern farm equipment going down the road. Are you too big?
Exactly.
Are you too heavy? And there are specific rules, and this is a combination of federal and state law. And sometimes the counties can have their own regulations on this, including mailbox rules, too. So you really have to check federal rules. You have to check state rules. Sometimes you have to check local rules. And then if you hit one, U.S. Postal Service regs say you need to notify the owner, the property owner of the box, even though it's federal property, the owner that is receiving mail in that box, and you need to notify the local police, and a report needs to be filed. And probably the worst thing that will happen to you if it's not intentional. Now, if it's intentional, you just intentionally damage federal property. Don't do that.
Yeah, that's not good.
Don't do what my colleagues did on the basketball team. Although I think ratting on them, we're 35 years beyond the statute. Well, 38 years beyond the statute of limitations. So I think we're okay, or they're okay. Yeah, I didn't. Yeah, I'm not implying that I was involved in that. But as long as it wasn't intentional, I think the worst that's going to happen to you is you're just going to have to pay for a new box for the person. But I think it's an interesting piece. It was an interesting question that came in. A lot of farmers do have that question. So that was yesterday's blog article.
Because it's, you never think about how many things go into if you want to put a mailbox out there.
And it's a practical problem for farmers taking equipment down the road. You see traffic coming, you pull over it. Oh, there's a box. I just wiped out a box.
Yep.
It happened.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us this morning. And Roger, got a couple of more things we're going to talk about. And one is concerning the American Rescue Plan Act, but specifically looking at a state tax provision that there were some changes or decisions were made on, too.
Yeah, the Congress tried something kind of slick in ARPA, the American Rescue Plan Act, and they said, we're going to give these states this money because of what happened to state budgets, so they're going to throw this money at the states. But then they put a catch on that, and they said, well, you can't use any of those funds, by the way, to cut taxes in your state. Well, there's a little bit of a problem with respect to that, and some states sued, and we just had a decision that came down about 10 days ago out of a federal district court in Ohio. And the court said, no, under the Constitution, Congress, you can't throw money at states. You can't give them federal taxpayer dollars and condition it on the states not cutting taxes at the state level. They said that's defective from a constitutional standpoint. And the Treasury does not have the authority to clarify the provision. They said the provision is too vague. This is a matter of state-level policy. We get into issues of federalism and the federal government kind of overstepping its boundary into the state domain. And the court said you can't do that under the spending. You can't use the spending clause to validate that, and you can't tell the Treasury to clean it up in regulations because we were so vague in saying what that meant. So that provision was struck down as unconstitutional, violated the spending clause of the Constitution. It was permanently enjoined by the federal district court in Ohio.
One other topic we want to discuss, and this, of course, is the couple of big decisions concerning the renewable fuels industry and the EPA, but specifically this one was the decision concerning the ability to sell E15 that can be sold at retail year-round, and there was a big court decision that came down on that late last week.
Yeah, there was, out of the D.C. Circuit Court of Appeals, so a very prominent court. A lot of people will view that as the most prominent circuit court of appeals in the United States. In fact, we have historically a lot of Supreme Court justices that come from that court, so this is a big court. This is not a federal district court. It's not one of the other circuits. It is the D.C. Circuit. And you're right. We've had two of these opinions over the past month, past 3 weeks, basically, involving ethanol. And this one was the issue of retailers being able to sell E15 through the summer months. And, of course, the problem has always been increased smog in cities if they are able to sell that in the summertime, the volatility of it. And the Trump administration had actually in 2018 directed the EPA to consider expanding that Reid vapor pressure waivers for fuel blends that contain gas and up to 15% of ethanol, the E15, so it could be sold year-round. They said, change that rule so it can be sold year-round. And so the EPA did. They issued a rule. It was mid-June last year, a revised rule. They went through the notice and comment procedure, so that wasn't an issue. And they revised the regs on fuel volatility and the renewable identification, or the RIN market. And then they changed their interpretation of when the limits on fuel volatility under the Clean Air Act could be waived. And you get into the weeds on some specific statutory language with respect to this one. And when it got into court, now the interesting thing about this was you had both the petroleum industry and the renewable fuels industry that sued the EPA on this, which is strange. But they're arguing over specific statutory language. And it's a particular provision. Actually, it's 42 U.S.C. 7545. And that interpretation has the language in it that allows fuel and 10% ethanol to be blended together. The Renewable Fuels Association said, well, Congress meant at least 10%. And so they wanted to read the words "at least" into the statute. And the petroleum industry was saying, well, no, it's pretty clear. We can blend 10%, but Congress didn't authorize anything other than that. And the court said, yeah, this is plain on its face. And when we have a statute that's plain on its face, they presume, now this may not be a good presumption, they presume that Congress knows what it is doing when it writes statutes. I always find that funny. I could chuckle a bit when I see a court say that. We always presume that Congress knows what they're doing when they write words. Okay. But they said this is plain on its face. It does not say at least. It says 10. And so 10 means 10. 10 does not mean 15. It does not mean anything more than 10. And so the court said, we're not going to look at any of this legislative history as to what their intent was when they wrote a statute that is crystal clear. 10 means 10. It does not mean 15. Therefore, the EPA, in allowing 15, violated the statute. It doesn't jive with the statute. And so they refused to look at legislative history, and they said that the EPA rule was not valid. It's as simple as that.
I would assume that since we're, a month into summer, basically, or almost a month into summer, that it wouldn't affect this summer as far as their ability to sell that, but you'd probably have to start looking at next summer where that would take effect.
Well, the court wiped it out immediately, so I think from going forward, I think what has already been blended, if I read this right, can be sold.
Okay.
But you can't add any more into the pipeline. And this throws it back to Congress on both this issue and the one we talked about last time. Congress has some work to do here. This cannot be cleaned up by the administrative agencies. So the ball is back in Congress's court to write the words that they mean in the statute. If that's what they mean, if they mean 15, they have to write 15.
And it's an election year next year, so
that is true.
We'll see what happens. Mm-hmm. All right, Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. He joins us on the Ag Issues program here on 580 WIBW.